The letter was not slipped under the door. It was not placed gently in the mailbox with the rest of the morning's mail. It arrived the way bad news always does when institutions are involved, in an oversized manila envelope, certified, requiring a signature that I did not want to give, but gave anyway because the postal worker was standing at my door at 6:47 in the morning, and I had a meeting at 8, and I was still in the clothes I had slept in because I had worked until 3, the night before, finishing a project that was due to a client, who paid on time, always, which is more than I can say for the people who raised me. I signed. I took the envelope. I stood in the doorway of my apartment on the 4th floor of a building in a city I had moved to specifically to build distance between my life and theirs, and I looked at the return address printed in official black ink on the upper left corner. Internal Revenue Service, Criminal Investigation Division. The words did not make me panic immediately. I am not someone who panics immediately. What I did was close the door, set the envelope on the kitchen counter, make a cup of coffee, and sit down in the chair by the window where the morning light was just beginning to come through at an angle that made the dust on the glass visible. I drank half the cup before I opened it. The document inside was 6 pages long. It was formatted the way government documents are formatted: dense paragraphs, numbered sections, references to code and statute that are designed to be legible to someone with a law degree, but not necessarily to anyone else. I read it carefully anyway. I read it twice. The document was a notice of federal tax lien. It was filed against a taxpayer whose social security number matched mine exactly. It listed unpaid federal income taxes for the years 2018, 2019, 2020, and 2021. The total liability, including penalties and accrued interest, was listed as $214,387. My name was not on the document. The name on the document was Raymond Dale Colton. I have never heard that name in my life. My social security number was on it, my address was on it. A phone number I did not recognize was listed as associated with the account. There was a case number, there was a contact agent, there was a deadline. The deadline was 30 days from the date of the notice, which had been processed 11 days ago, meaning I had 19 days to respond before the IRS could begin levying assets associated with the social security number listed, which was mine, which meant my bank accounts, my wages, my apartment security deposit, anything the government could see that had my number attached to it, could be frozen, seized, or redirected to satisfy a debt belonging to a man named Raymond Dale Colton. I read the document a third time. Then I picked up my phone and called my mother. She answered on the second ring. It was 7 in the morning and she answered on the second ring, which told me she was either awake already or had been waiting for exactly this call. "There is an IRS notice at my apartment," I said. "It has my social security number on it, and someone else's name. I need you to tell me right now if you know anything about this." The pause that followed was approximately 4 seconds. 4 seconds is not a long time in a conversation between two strangers. Between a mother and her child, 4 seconds is a confession. "Where did you get that number from?" She said, not a question. A deflection shaped like a question. "The number is my social security number," I said. "The same number on my tax returns, my employer records, my bank accounts. It has been my number since I was born." "Who is Raymond Dale Colton?" Another pause. Shorter this time. 2 seconds. "I don't know what you're talking about," she said. I hung up. I sat with the document in my hand for another 20 minutes. I was not spiraling. I was thinking. There is a difference, and the difference matters. Spiraling produces no useful information. Thinking produces a list of what you know, what you do not know, and what you need to find out in a specific order. What I knew, my social security number had been used to file tax returns under a different name for 4 years. What I did not know, how this had happened, who had done it, what the financial structure looked like, and whether my mother's 4-second pause meant she was involved, or simply knew who was. What I needed to find out, in order, the full scope of the filing history attached to my number, whether any legitimate IRS accounts were attached to my number under my own name, and who Raymond Dale Colton was. I called in late to my meeting. I told my client there was a family emergency, which was accurate. Then I took the certified notice, my own tax records for the previous 4 years, which I kept in a fire-resistant file box under my bed because I am the kind of person who keeps things, who saves things, who does not throw away documentation. And I drove to the office of a tax attorney whose name I found through a colleague who had gone through an audit 2 years prior and described the attorney as someone who did not waste words or invoice hours. Her name was Delphine Marsh. She was in her early 60s, wore reading glasses on a chain around her neck, and had a wall in her office covered entirely in framed certificates and bar admissions for 6 different states. I showed her the notice. I showed her my 4 years of filed returns. She read everything without speaking. When she finished, she took off her glasses, set them on the desk between us, and said, "Your number has been used to run a secondary tax identity. This is not an audit. This is identity theft with tax fraud components. The question is when it started and how far it goes." "I want to know who Raymond Dale Colton is," I said. "That name may be a fabrication," he said. "Or it may be a real person who was paid to lend their name to a filing structure someone else was running. Either way, what we need to pull first is your complete IRS transcript. We request it today. We get the full history of every return filed against your Social Security number for every year on record. Once we have that, we know the scope." She submitted the transcript request that morning using Form 4506-C. She told me the standard processing window was 5 to 10 business days, but that given the lien notice and the deadline, she would mark it urgent and call the Taxpayer Advocate Service directly to expedite. She also told me to place a fraud alert with all 3 credit bureaus before I left her office, which I did from my phone while sitting in her waiting room. Equifax, TransUnion, Experian. Each call took approximately 8 minutes. Each representative was professional and scripted. None of them could tell me what had already been filed against my number. What they could do was flag the account so that no new credit could be opened without additional verification. What was already open, what had already been done, was still there, waiting to be found. I drove home slowly. Not because I was in shock, because I was composing a mental list of everything I needed to document over the next 19 days, and I wanted to do it carefully before I wrote a single thing down. Because once something is written, it becomes a record, and I have always understood that records are the only language institutions actually speak. The transcript came back in 4 business days. Delphine called me at 8 in the morning, and I asked me to come in within the hour. I was already at her office by 8:45. She had printed everything and laid it out on the conference table in order. My legitimate returns, filed under my name, my address, my employer, were on the left side of the table. The fraudulent returns, filed under Raymond Dale Colton, using my Social Security number, with a different address in a different state, listing income from a business entity I had never heard of, were on the right side. The fraudulent returns went back further than the notice had indicated. They did not begin in 2018, they began in 2015. I was 22 years old in 2015. I had just moved to the city, I had just started my first real job. I was filing my own taxes for the first time as an independent adult, using a straightforward W-2, living in a studio apartment, making $41,000 a year. And simultaneously, according to the IRS transcript, a separate entity was filing returns using my Social Security number through a small business registered in the state where my parents lived, reporting income, deducting expenses, and paying partial taxes in a way that looked, on paper, like a functioning sole proprietorship with reasonable cash flow. 7 years of filings. 7 years. The business name was listed on the returns as Colton Home Services LLC. I searched the name in the state corporate registry that afternoon. The registered agent for Colton Home Services LLC, from the date of formation in 2014 through its administrative dissolution in 2022, was listed as Gerald Thomas Ashe. That was my father's name. I sat in Delphine's office and I did not say anything for approximately 30 seconds. 30 seconds of silence in a room with another person is a long time. Delphine did not try to fill it, she understood what I had just seen. "He formed a LLC in 2014, I said finally. "The year before the first fraudulent return," she said. "I was 21 in 2014, I said. "I was still on their insurance. I was home for Christmas. He would have had access to my Social Security card." "Access to your card is enough," she said. "He would have needed the number for the initial LLC registration if he listed you as a member or employee, which he may have done in internal documents, even if the public registration only showed him as agent. Once the number is attached to the business entity, it becomes part of the filing infrastructure." 7 years, I said. "The total unreported liability accumulated under your number, including penalties and interest on all filings going back to 2015, is $261,412, she said. "The current lien notice only captures 2018 through 2021 because that is where the IRS's automatic systems flagged the discrepancy between your legitimate filings and the parallel filings. The 2015 through 2017 period is in a separate queue and has likely already triggered a secondary review that has not yet generated formal correspondence. So there was more coming. The letter that arrived at dawn was not the only letter, it was the first letter. "What do I file?" I said. "We file an identity theft affidavit immediately," she said. "Form 14039. We attach every piece of documentation we have showing your legitimate filings, your employment records, your W-2s, your actual addresses and phone numbers for each year the fraudulent returns were filed. We also file a police report today, not because the police will investigate quickly, they usually don't tax fraud cases, but because the police report number becomes part of your IRS submission, and it establishes a timeline and an official complaint record that protects you procedurally." "And my father," I said. She looked at me steadily. "The IRS does not need you to name him. The corporate registry already connects him to the business. When the Identity Theft Unit cross-references the LLC registration records with the Social Security number fraud investigation that your affidavit will trigger, the connection will surface on its own. Your job is not to accuse him. Your job is to document yourself." That distinction mattered to me more than I expected it to. She was telling me that the system would find him, that I did not have to be the one to point the finger, that records properly submitted would do the work that no amount of confrontation could do cleanly. We filed Form 14039 that afternoon. Delphine prepared the affidavit, and I reviewed every line. My name, my address history, my employment history, my correct Social Security number, the fraudulent filings identified by transcript, the business name, the state of registration, the date of administrative dissolution, the registered agent. We did not write my father's name anywhere in the affidavit. We did not need to. The documents attached to the affidavit named him by structure. I went to the police that evening, the nearest precinct to my apartment. I spoke to a records officer who was clearly accustomed to taking reports for low-priority incidents and treating them as administrative events rather than investigations. I gave her the facts in sequence. My Social Security number had been used without my knowledge or consent to file tax returns for 7 years. The filings were attached to a business entity registered in another state. I had the IRS transcript documenting the discrepancy, and I was filing an identity theft affidavit with the IRS. She typed while I spoke. She printed a report number. She told me that cases involving IRS fraud were typically referred to federal investigators, and that her department's role was limited to documentation unless there was a parallel state crime involved. "There may be," I said, still determining the scope. She added a notation to that effect. I took the report number and left. I called my mother again that night, not because I expected honesty, because I needed a record of the conversation. "I went to a tax attorney today," I said. "I have the IRS transcript showing 7 years of fraudulent filings attached to my Social Security number. The business used is Colton Home Services LLC, registered in your state. The registered agent is Dad. I filed a police report this evening. I filed an identity theft affidavit with the IRS this afternoon. I'm telling you this because you are my mother, and I thought you should know before the formal process moves forward." The silence this time was different. It was not the 4-second calculation of the first call. It was longer, and underneath it I could hear her breathing, which was slightly elevated, which told me that she was aware, had been aware, possibly had been aware for years. "Your father has been in some financial trouble," she said. "He was trying to keep the business going. He didn't think it would go this far. He used my Social Security number," I said. "He was going to fix it," she said. "For 7 years he was going to fix it," I said. "He loves you," she said. That sentence was the most useless sentence she could have offered me at that moment, and I think some part of her knew it as she said it, because her voice dropped slightly at the end of it, like a note held too long falling off pitch. "I need you to understand something," I said. "This is no longer between him and me. The IRS is involved. There is a federal lien on my Social Security number, there are police records, there is a tax attorney. Whatever happens next is going to happen inside a system that doesn't care about love or intention or financial trouble. It processes documents, and the documents are already moving." I hung up again. I did not sleep well that night, but not because I was upset. I was processing, going through the timeline in my head. 2014, the LLC is formed. 2015, the first fraudulent return is filed. 2015 through 2017, partial taxes are paid, no red flags generated, the operation looks functional. 2018, something changes. Maybe the business hits a rough patch. Maybe my father stops making the partial payments. Maybe he begins deducting more than he earns. The returns for 2018, 2019, 2020, and 2021 show increasing liability and decreasing payment. By 2021, the IRS system catches the discrepancy between my legitimate filings and the fraudulent parallel filings because both are associated with the same Social Security number and the combined reported income does not match the combined tax payments. The system flags it. An investigation opens. The lien is filed. The letter arrives at my door at 6:47 in the morning. The question I kept returning to was whether my mother had known the entire time or only at some point along the way. The 4-second pause on the first call suggested she knew before I called. Her answer on the second call, he was trying to fix it, suggested she had been in the information loop for long enough to have developed a narrative for it. Whether she had participated directly in the filings or simply known about them and said nothing was a question with different legal implications, and I brought it to Delphine the next morning. For your purposes, her level of involvement is secondary, Delphine said. The IRS investigation will sort that out. What matters for your affidavit is the documented evidence that the filings were not yours. We have that. What we need to build now is your complete timeline of residence, employment, and activity during the years in question, so that when the IRS Identity Theft Unit reviews your affidavit, there is no gap in your personal record that could be misread as collaborative. We spent 3 hours that morning building the timeline. Every address I have lived at since 2014. Every employer, every filed return. Bank records showing deposits that matched my reported W-2 income exactly. Lease agreements, utility bills. Every document I had that placed me in a different city, working a different job, living a different life, from the one the fraudulent returns were describing. The picture that emerged from my records was clear and consistent. I had been a W-2 employee in the same city for most of those 7 years. I had never owned a home service business. I had never registered a business entity in any state. I had never had employees, subcontractors, or commercial accounts. My income had grown modestly and predictably in the way that salary income grows for someone who receives standard annual increases and occasional promotions. There was nothing in my record that looked like the income pattern of a sole proprietorship, because a sole proprietorship has irregular cash flow, variable deductions, and seasonal patterns that are structurally distinct from salaried employment. Delphine submitted the completed timeline documentation to the IRS Identity Theft Unit the following morning, attached to her previously filed Form 14039. She also submitted a request for a taxpayer advocate through the Taxpayer Advocate Service, citing the active lien and the pending second review period as grounds for expedited handling. The advocate assigned to our case was a man named Keith Bradigan, whose voicemail message was professionally clipped, and his callback time was less than 4 hours, which was faster than I had expected from a federal agency. He called at 2 in the afternoon. He had reviewed the submission. He confirmed that the case had been flagged internally as a potential identity theft with third-party perpetrator involvement. He said that the standard review process for identity theft cases ran 8 to 12 weeks, but that the combination of an active lien, a concurrent criminal investigation flag, and the volume of documentation we had submitted placed it in an accelerated queue. He could not promise a timeline. What he could tell me was that a hold had been placed on any levy action associated with my Social Security number, pending the outcome of the review. The 19-day deadline on the original lien notice was no longer operative while the hold was active. The assets I had been worried about, my bank accounts, my wages, my security deposit, were safe for now. Procedurally safe, not permanently resolved, but protected long enough for the system to do what it was designed to do. I thanked him and ended the call. Then I sat in my office, which is a corner of my apartment with a second-hand desk and a good lamp, and I thought about my father for the first time that week without organizing it into a list or a timeline or a sequence of actions. Just thought about him, thought about the person I had known growing up. The man who had taught me how to change a tire and how to read a map when I was old enough to understand that knowing how to find your way was worth more than knowing how to call for help. The man who had driven 4 hours in a snowstorm to help me move out of my first apartment when the landlord turned out to be dishonest, and I needed to leave in a single day. The man who had, at some point between then and now, looked at the situation he was in and made a calculation that using my Social Security number was a solution worth trying. I wanted to believe there was a version of that calculation that made sense. A version where the need was so acute and the timeline so compressed that the decision had felt temporary, manageable, reversible, But 7 years is not a temporary decision. 7 years of filings, of renewal, of actively maintaining a fraudulent structure attached to another person's identity. That is not a panicked mistake. That is a choice, made and remade each year, each quarter, each time the return was prepared and signed and submitted. I filed that thought in the same place I file things I need to hold but cannot act on. Then I went back to work. 11 days after our submission to the Identity Theft Unit, Delphine received a formal acknowledgement letter confirming the case had been opened, assigned a case number, and assigned to a specific IRS criminal investigation agent. The name on the letter was Special Agent Marcus Tillman, Internal Revenue Service, Criminal Investigation. His contact information was included. He had already been assigned before the acknowledgement letter was generated, which meant the criminal referral had happened faster than the standard timeline suggested. Delphine called me the morning she received the letter. Criminal investigation doesn't get involved in standard identity theft resolutions, she said. They get involved when the fraud is large enough in dollar amount or long enough in duration to meet federal prosecution thresholds. 7 years and over $260,000 in total liability puts this squarely in their jurisdiction. Are they going to want to talk to me? I said. Almost certainly, she said. When they do, we go together. You answer questions directly and completely, and you say nothing beyond what is asked. You have nothing to conceal, but that is not the same as having nothing to protect. Every statement you make in that room becomes part of the record. Special Agent Tillman called my attorney's office the following week. He requested an interview. Delphine scheduled it for a Friday morning at the IRS field office located 12 blocks from my apartment. I wore the same suit I wore to professional presentations. I brought nothing to the meeting except a manila folder containing a printed copy of every document we had submitted. The interview room was small and clean. Agent Tillman was in his 40s, wearing a navy suit and no tie. He had a legal pad and a recording device, which he identified and confirmed I had consented to. Delphine sat to my left. He sat across from both of us. He began by confirming the timeline of my legitimate filings. W-2 employer for 2015 through the present. Salaried income, single filer, no business income, no self-employment income, no partnership interests, no ownership in any registered business entity. I confirmed each point. He asked if I had ever given my social security number to my parents for any purpose other than standard family documentation, such as childhood insurance or school enrollment. I told him I had not knowingly provided it for any financial or business purpose after reaching adulthood, and that to my knowledge the last legitimate use of my number by my parents had been for my father to list me as a dependent on his tax return, which ended when I turned 23 and was filing my own returns independently. He asked about Colton Home Services LLC. I told him I had no knowledge of its existence until I identified it through the state corporate registry after receiving the lien notice. I told him the registered agent was my father. I told him I had never been contacted by the business, never received any income attributed to it, never had any account, card, or financial instrument issued in connection with it. He wrote on his legal pad in a consistent, unhurried way that suggested he already had most of this information, and was confirming rather than learning. Then he asked one question that was different from the others in its structure. Mr. Ash, he said, in the years 2015 through 2021, did your parents ever make payments to you that you did not report as income? Cash payments, transfers, gifts over the annual exclusion threshold? I understood what he was asking. He was checking whether the fraudulent operation had generated money that had flowed to me, which would change the legal character of my involvement regardless of whether I had consented to the use of my number. No, I said. I have bank records for every year in question. My deposits are consistent with my W-2 income and occasional small transfers from my own savings accounts. There is nothing in those records that reflects a payment from my parents above the level of an occasional personal gift, none of which exceeded a few $100s, none of which I would have been required to report. Would you consent to a review of those bank records? He asked. Yes. I said immediately. Delphine had prepared authorization forms in advance. She slid them across the table. He initialed them. The interview lasted 1 hour and 14 minutes. At the end of it, he stood, thanked me for my cooperation, and said that my status in the investigation was that of a victim of tax identity theft, not a subject. He told me that I should expect further communication from both the Identity Theft Unit and his office over the coming weeks. Walking out of the federal building into the cold morning air, Delphine said, "You did well. He had your records before you walked in. The interview was verification protocol. They already know where they're going with this." "Where are they going?" I said. "Your father," she said. The question is whether they'll stop there, or whether the scope of the investigation expands depending on what they find in the business accounts. I asked her what my mother's legal exposure looked like. She said it depended entirely on what, if anything, connected her to the filing structure beyond the knowledge she had revealed to me in the phone call. She pointed out that the phone call itself was not a legal document, that I had not recorded it, and that my characterization of what she had said was my word alone, which would not be admissible as evidence in any formal proceeding. What mattered for my mother's legal situation was what the financial records showed, not what I believed she knew. That was a legal answer, and it was the correct legal answer. I accepted it. The bank record review took 2 weeks. At the end of the second week, Delphine received a call from Agent Tillman informing her that the review of my personal financial records had confirmed my status as a non-participating victim with no financial benefit from the fraudulent filings. He also informed her that the IRS Identity Theft Unit had completed its initial review of my affidavit and the supporting documentation and had made a determination. I was formally cleared of any tax liability associated with the fraudulent returns. The lien filed against my Social Security number would be formally released within 10 business days. A written confirmation and release document would be issued to me directly. $261,412 in fraudulent tax liability. Released, cleared, removed from my record. It took 7 weeks from the morning the certified envelope arrived to the morning I received the written confirmation. 7 weeks of documents, interviews, authorizations, and waiting. The waiting was the hardest part, not because of anxiety, but because of the gap between knowing something and being able to prove that you know it. I knew from the first week that I had done nothing wrong. I knew it so completely and with such clear documentation that the outcome felt inevitable. But the inevitable outcome still required 7 weeks of formal process to confirm itself, and in those 7 weeks I had to continue going to work, paying rent, answering emails, and existing inside a life that was temporarily attached to a financial threat I had not created and could not immediately remove. I want to describe what happened after the clearance was confirmed, because what happened after is not what I expected. I expected to feel relieved. I did feel relieved, but it was a narrow, technical relief, the kind you feel when a process completes correctly, rather than the kind you feel when something good happens. The lien was released. My financial records were clear. My Social Security number had been formally flagged in the IRS system with a taxpayer identity protection indicator, which means that going forward any return filed against my number that does not include a specific PIN issued directly to me would be flagged immediately as fraudulent. My financial identity was, for the first time in 7 years, actually mine. What I did not expect was the second letter. It arrived 3 weeks after the lien release confirmation. This one was not certified. It was in a standard envelope with my correct return address on it, which told me it came from someone who knew my address but was not using an official channel. Inside was a single sheet of paper, my mother's handwriting. 3 paragraphs. The first paragraph said that my father had received a letter from the IRS informing him that he was under investigation for federal tax fraud and identity theft. The second paragraph said that his attorney had told him the investigation was serious and that the documents already submitted to federal investigators were sufficient to support federal charges. The third paragraph said that she hoped I understood that she and my father had never meant for this to become what it had become, and that whatever happened next, she wanted me to know that the family was still the family. I read it once, I set it on the desk, I did not write back. I did call Delphine. I told her about the letter. She said it was not legally significant for my case, which was closed. She said that if I received any further communication from my parents that could be construed as pressure, intimidation, or an attempt to influence the federal investigation, I should forward it to Agent Tillman immediately, but that a personal letter expressing regret without making any specific request was unlikely to fall into that category. What happens to him, I said. Federal tax fraud and identity theft charges at this dollar amount and duration typically carry significant penalties, she said. Prison time is possible. Substantial financial penalties are likely. The IRS will pursue recovery from assets connected to the business. Whether there is additional state-level exposure depends on whether the investigation turns up violations of state tax law, which it likely will. And my mother, I said, that depends on what they find in the financial records, she said again. I don't have visibility into that. I thanked her. I wrote her a check for the remainder of her invoice. Her fee for 7 weeks of work, including the formal submissions, the advocate coordination, the IRS interview preparation, and the bank record authorization process, was $14,600. I paid it. It was a significant amount of money for a salaried employee who kept a budget. It was also less than the cost of having done nothing, which would have been $261,000 plus every asset I owned. The math was simple. The math is always simple when you have documentation. What I want to spend time on now is something that does not get discussed often in stories like this one, which is the internal experience of being wronged by someone who is supposed to protect you. Not the emotional experience. I have spent enough time on the emotional experience in my own private thinking, and it does not belong here. What I mean is the practical, cognitive experience of having to hold two truths simultaneously for an extended period. The first truth was that my father committed a federal crime against me. He used my identity without my consent. He built a financial structure on my social security number and operated that structure for 7 years, while I was in another city building a legitimate life, completely unaware that my name, not even my name, my number, my government identifier, the thing I did not choose and cannot change, was the foundation of a fraud. He was not desperate in 2014. The business records showed steady revenue. He was opportunistic. He saw a gap in the system and used his own child to fill it. The second truth was that this was the same man who drove 4 hours through a snowstorm to help me move, who taught me how to read a map, who was present, physically and emotionally, for long stretches of my childhood in ways that mattered to me, and still matter to me even now when the legal picture is what it is. Holding those two truths without collapsing one into the other, without deciding that the crime erases the good or that the good excuses the crime, is the actual work that does not have a document to file or a form to submit. It is internal work. It is slow work. I am still doing it, but I will tell you this. The part of that work that I have resolved most fully is the part about the system, about documents and records and formal processes, because here is what I know to be true after those 7 weeks and everything that came after them. The system did not fail me. Not ultimately. The system was used against me, by my father, who knew how to use it because he had spent years navigating it in his business. But when I entered the system correctly, with documentation, with legal representation, with precision and patience, the system reversed course. It did exactly what it is designed to do when operated correctly. It saw the evidence. It followed the evidence. It cleared the victim and directed its attention toward the perpetrator. People are complicated. Family is complicated. The emotions involved in being betrayed by a parent are not things that resolve cleanly or quickly, or in the order you expect them to. But systems, when they work, are not complicated. They follow logic. They follow documentation. They respond to facts in sequence. My father built his fraud on the assumption that I would never look closely, or that by the time I did it would be too late for the system to see what he had done clearly enough to act. He underestimated two things. He underestimated my habit of keeping records, and he underestimated the fact that the same system he had been manipulating was designed, at its core, to detect exactly the kind of manipulation he had been running. The investigation formally concluded 8 months after the lien release. I know this because Delphine received a final communication from Agent Tillman's office confirming that my involvement in the case had been formally closed and that I would be contacted only if testimony was required in any subsequent proceedings. She forwarded the communication to me. I printed it. I added it to the file box under my bed, which now has a full section dedicated to this matter, organized chronologically, complete from the morning the certified envelope arrived to the morning I received the final clearance communication. My father was indicted on 4 federal counts: tax fraud, identity theft under the aggravated identity theft statute, filing false returns, and conspiracy. I did not attend the indictment proceedings. I did not need to. The documents attended for me. My mother was not charged. The financial investigation did not turn up evidence of her direct participation in the filings. She knew, but knowing and participating are different things in law, and the law was precise about the distinction. I did not feel vindicated by her non-indictment, and I did not feel betrayed by it. It was the system applying the same standard to her that it had applied to me. What do the records show? I have not spoken to either of my parents since the night I called my mother to tell her that the documents were already moving. That was my choice, made quietly and without announcement. Not in anger, though anger was present. In clarity. There are relationships that can withstand what happened in that courtroom and that investigation, and there are those that cannot, and I know enough about myself to know which category mine falls into. I am not permanently closed, but I am not currently open, and the difference matters. What I want to say to you, to anyone watching this who is sitting with a similar situation, or something adjacent to it, is this. There is a version of this story in which I do nothing. In which I receive the letter and I feel the fear that any reasonable person would feel, and I call my parents and they say what they said, and I decide that the complexity is too much, that the damage to the family would be irreversible, that maybe I can find some other way to deal with it quietly. There is a version in which I try to negotiate with a system that does not negotiate, in which I hope that the problem resolves without my active participation, in which I wait. I did not take that version, not because I am exceptionally brave or exceptionally cold, but because I have always understood, at a fairly basic level, that inaction in the face of a documented wrong is itself a decision, and that decisions made by default rather than by choice tend to produce outcomes that belong to someone else's agenda, rather than your own. The lien would not have released itself. The investigation would not have found me without my affidavit. The fraud would have continued accumulating against my number indefinitely if I had not entered the formal system with documentation in hand and a clear statement of what I was and was not. Records matter, not because they are cold or because they replace the human dimension of what happened, but because they are the only language in which a system can hear you. You cannot argue with a tax lien. You cannot appeal to an IRS agent's sense of family loyalty. You cannot explain your way out of a federal fraud investigation using emotion. What you can do is document who you are, where you have been, what you have earned, what you have paid, what you did not sign, what you did not authorize, and present that documentation through the correct channel at the correct time, with the correct legal support. The system heard me. It took 7 weeks and $14,000 and a level of sustained focus that I had not previously been required to maintain in my personal life. But it heard me, and it acted. I have thought about whether I would have handled any of it differently, whether there was a moment where I could have called my father directly, before the attorneys and the affidavits and the criminal referrals, and had a conversation that changed the trajectory. I have thought about it seriously, and my honest conclusion is that by the time that letter arrived at my door, the conversation window had closed. Not because my father is a bad person in every dimension of his life, but because the structure he built had already existed for 7 years, and a person who maintains a fraud for 7 years has already had thousands of private moments in which they could have stopped, reversed, confessed, or simply called their child and said, "I made a terrible decision and I need to fix it." He had not taken any of those moments. The structure persisted until the system found it. That tells me everything I need to know about what a private conversation between us would have produced. There is something important I want to be precise about, which is the role my attorney played in this. Delphine Marsh did not win this for me. She processed it for me. The distinction is meaningful. The case was won by the records. By the W-2s I had kept in a fire-resistant file box under my bed for years, not because I anticipated this moment, but because I am someone who understands that documentation of a legitimate life is never wasted. By the bank records that showed my income was exactly what I said it was, every year without exception. By the employment records that placed me in a different city from the one where the fraud was being run. By the state corporate registry that listed my father's name in black ink as the registered agent of the business that had been running under my number. My attorney translated those records into the correct formal language, for the correct formal processes, and submitted them through the correct channels in the correct sequence. That expertise was worth every dollar of her invoice, but the records themselves, those were mine. I made them by living correctly, by paying my taxes, by keeping my paperwork, by being year after year, exactly who I said I was. Nobody can take that from you. A person can steal your social security number. They can attach a fraudulent business to it. They can run that business for 7 years. But they cannot retroactively falsify your employment records, or your bank deposits, or your lease agreements, or your utility bills. The authentic record of a real life is resistant to fraud in a way that purely financial documents are not, because the authentic record is distributed across dozens of independent sources that have no relationship to each other, except that they all recorded the same person doing the same consistent things over time. My father's fraud was ultimately exposed, not because investigators were particularly clever, or the IRS system was particularly vigilant, although both of those things were factors. It was exposed because the record of my actual life was incompatible with the record of the life he had assigned to my number. Those two records could not coexist in the same database without creating a contradiction, and the contradiction was visible to anyone looking at both sides simultaneously. What I did when I arrived at Delphine's office was make sure that the correct authority was looking at both sides simultaneously. That is all it was. That is the whole architecture of the resolution. Not heroism, not a confrontation, not a dramatic moment in a courtroom where the truth finally comes out. Just documentation, submitted correctly to the right people at the right time in the right format. I want to close with something about what the following year looked like, because the story does not end with the lien release or the indictment or the final clearance letter. It continues into the ordinary days that come after, and those days have a particular quality that I did not anticipate. The year after this was resolved was quieter than any year I can remember. I still went to work, still paid my taxes on time with full documentation as I always had. I received my taxpayer identity protection PIN in the mail in January, a 6-digit number that I now include on every return I file, which ensures that no return can be processed against my Social Security number without it. The PIN renews annually. I mark the renewal date in my calendar 6 weeks in advance. I built a better filing system, not just for tax records but for everything. Insurance policies, medical records, employment contracts, lease agreements, photographs of physical documents that might deteriorate, a cloud backup and a physical backup, redundant systems for things that cannot be replaced. I had already been reasonably organized before this happened. After this happened, I became thorough. I was careful with my credit in ways I had not been careful before. Not anxious, careful. I checked my credit reports quarterly. I reviewed my Social Security earnings statement through the official SSA portal to confirm that the income attributed to my number each year matched my actual reported wages. I flagged a discrepancy in the first quarter of the year after the resolution and reported it immediately. It turned out to be a data entry error by a payroll processor. Not a fraud attempt, and it was corrected in 3 business days. The point is, I found it in 3 months rather than 7 years. I thought about my father at odd times, driving in the quiet before sleep. On the anniversary of when I received the letter, which I know because it was in my calendar, not because I was marking it, but because the police report and the attorney's initial meeting both referenced the date. And those dates were in my records, and I am someone who looks at records when they appear. I thought about him with a kind of detached sadness that I suspect will be the permanent texture of my feeling toward him. Not grief exactly. Not rage. Something more like the feeling you have when you see a building that used to be something else. A recognition that what was there before is gone, and what replaced it is real and present and has its own character, and the before and the after are both true, but they are no longer the same place. My mother sent one more letter 6 months after the first one. It was shorter. It said she was sorry, not for what had been done to me specifically, not in that words, but that she was sorry for how things had gone. I read it. I said it in the file. I have not written back. There is a version of maturity that says you must forgive, that forgiveness is for you, not for the other person. That carrying weight is its own punishment. I have heard all of those arguments and I find them earnest and sometimes true and not applicable to every situation. What I know is that forgiveness is not a prerequisite for function. I am functional. I am more than functional. I am clear. The clarity came from the documentation, from the process, from the resolution, and it does not require a completed emotional arc to remain in force. I am clear and I intend to stay clear, and if the emotional arc completes itself over time, I will accept that, and if it does not, I will accept that too. The IRS website has a page titled, Taxpayer Guide to Identity Theft. I read it the week after the clearance letter arrived. I read it not because I needed it at that point, but because I wanted to understand how the system described itself in plain language, separate from the formal statutory language of the notices and the interview transcripts. The page is written in clear, direct prose. It tells you to file a Form 14039 if you believe your identity has been used for tax fraud. It tells you to contact the Taxpayer Advocate Service if you need assistance navigating the process. It tells you to file a police report. It tells you to protect your records. It describes in plain language exactly what I did. Not because I had read that page before going through this. I had not. But because those actions are the correct actions, and when you respond to a clear wrong with clear documentation and clear process, you tend to arrive at the same conclusion regardless of whether you had a map in advance. That is the most honest thing I can say about all of it. There was no secret knowledge that saved me. There was no clever move, no dramatic confrontation, no single document that reversed everything in one moment. There was sustained, patient, methodical attention to what the record showed and what the system required. There was a good attorney who knew the process. There was a taxpayer advocate who answered in 4 hours. There was a federal agent who reviewed the documents without prejudice and followed them where they led. And there was me, sitting in the chair by the window, with the morning light coming through the dusty glass, reading a 6-page government document 3 times before I made a single phone call. If you have found yourself in a version of this situation, not necessarily this situation, but a version in which someone you trusted used something of yours without your knowledge, and now the consequences are coming to your door instead of theirs, then I want you to know that the path out is not intuitive. It is not emotional, it is not a confrontation that ends with honesty, it is documentation, it is formal process, it is the patient accumulation of evidence that the record of your real life does not match the record of the wrong they pin to you. Enter the system correctly, and the system will hear you. Not quickly, not without cost, but correctly. The outcome that belongs to you is retrievable, because the record that proves it is yours has always been there, distributed across the ordinary documents of an ordinary life lived honestly. That is what I want you to take from this. Not the anger which fades, not the fear, which resolved, not even the resolution itself, which was procedural and precise and less satisfying in the moment than I expected. What I want you to take is the understanding that your authentic record is your most durable asset. Protect it, maintain it, know where it is and what it contains. Because the day may come when you need it to speak for you in a room where emotion has no standing, and on that day, the only voice that will be heard is the voice of documentation. It will be enough. It was enough for me. If any part of this story resonated with you, I want to hear from you in the comments. Not because I need validation, but because these situations are more common than most people realize, and the more they are spoken about in honest, specific terms, the better prepared the next person will be when the certified envelope arrives at their door. And if you are already in the middle of something like this, if you are holding a document you do not understand from an institution you did not contact, and somewhere in your history there is a person who should know more about it than you do, start where I started. Read the document, find the attorney, file the form, trust the record is already there. You made it by living, let it work.